Good evening. At this time, I would like to call the meeting to order. Today is Thursday, November 14th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino, Tongva, and Gabrielino Kizh peoples. If you will all please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and liberty and justice for all. Thank you. Mr. Secretary, may we please have a roll call?
Commissioner Goldman?
Here.
Commissioner Kirpies?
Here.
Commissioner McCafferty?
Here.
Commissioner Paris?
Here.
Commissioner Topshin?
Here.
Vice Chair Rory?
Here.
Chair Bess?
Here. We're all here, so we have a quorum. Has everyone had a chance to review tonight's agenda?
I move approval.
We have the motion. Is there a second?
Second.
Mr. Secretary, may we please have a roll call, please?
Commissioner Goldman? Aye. Commissioner Kirpies?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
Chair Bess?
Aye, and the motion carries. The next item on our agenda is the approval of the minutes. Has everyone had the chance to review the minutes of our October 24th meeting? If there are no changes, is there a motion to approve?
So moved.
Second. We have a motion, a second. Mr. Secretary, may we please have a roll call?
Commissioner Goldman?
Aye.
Commissioner Kirpies?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
Chair Bess?
Aye. The motion carries. We're on to item number 6, which is public comment. Do we have any public speakers?
Not at this time.
Thank you very much. There will be an opportunity at the end of the meeting, should you choose to speak on an item that is not on one of our appeals this evening. You can do that at the end of the meeting. Now, item number 7, the manager's report. Mr. Kessinger, do we have a report?
Yes, thank you. And good evening, commissioners. Hope you all are doing well. For tonight, we'll be hearing Appeal D4884 and D4877. Closing out the year, the December 12th and December 26th meetings have been canceled. Moving into 2025, we have 3 appeals scheduled for January 9th, January 23rd, February 13th, and February 27th, concluding on this calendar with 1 appeal for March 13th. And that concludes the look at calendar manager report at this time. Thanks.
Thank you very much. Do we have any questions for the city staff at this time? Thank you. Oh, Vice Chair?
I did have one just to make sure, because this will be our last meeting of this year. So for the schedule for next year, is that pretty well set in place? There's going to be 3 appeals likely heard per meeting in January into February?
Correct. It's pretty set. What might change is if there's a withdrawal. For example, that happened this evening. We had originally planned for 3, but 1 was withdrawn. That could change the number, and we might not be able to add another appeal depending on when that withdrawal is submitted.
Okay.
So we have a very busy schedule ahead. I hope everyone is able to attend.
And if not, we can make sure we know, for the staff knows for quorum purposes.
Thank you very much. We are now at the appeals portion of our agenda, item number 8, and we have 2 appeals before us this evening. The first appeal for this evening is appeal number D4884 for 1043 North Genesee, number 8. And Mr. Secretary, do we have a representative of both the tenant and the landlord?
Yes.
They're both present. So the way this works is that the first thing we'll do is we'll hear a staff report from our legal counsel. At that point, the appellant, and in this case that is the landlord, will have an opportunity to speak. You have 5 minutes to speak. You can divide that time however you like. If you want to speak for 4 minutes and save 1, 2.5, 2.5, however you want. We just ask that you let us know up front so that we can give you a time warning. After that, we will hear from the tenant, the respondent, and if there's any public comment, we'll hear that at the third, and after that, the landlord will have the opportunity to make a rebuttal. Then we'll enter into deliberations. I go through that detail because it'll be the same process on the second appeal. So at this point, I would like to ask our legal counsel if we can get a report, please.
Hello, Commissioners. My name is Kellen Martz, Legal Counsel of the Rent Stabilization Commission. The first appeal tonight is D-4884, 1043 North Genesee Avenue, number 8. In this matter, before the Commission is whether their MAR, or the maximum allowable rent, was properly determined, whether the landlord accepted and retained rent in excess of what is permitted by law, and whether there was a substantial reduction in housing services to warrant a rent decrease under the Rent Stabilization Ordinance. In this matter, the tenant has lived in the unit since approximately November 2020. The tenant filed for the rent decrease and MAR application in March of 2024. The hearing examiner in their decision found that the tenant was entitled to a rent decrease of $50 for the rent reduction in housing services due to maintenance issues with the garage. That was applied to all tenants because this was a common area issue. The hearing examiner also found that the unit had not been registered properly with the city, and therefore there was excess rent that had been retained by the tenant in violation and above the MAR. The hearing examiner ordered $2,788.36 to be returned or refunded to the tenant. Tonight, the landlord has appealed that decision. They've argued that the determination is clearly in error and is not reasonably supported by the findings or the evidence in the record. Staff's recommendation is that the Commission reverse the hearing examiner's decision on the garage door matter and that they modify the hearing examiner's decision on the MAR and rent overcharge. And I'm going to, one of the commissioners wrote in a question, and I want to read the answer into the record because if it comes up, you all have the same information. So the question was, do the lease that was provided in the appeal, is that considered new evidence? And can that be accepted, and how does the Commission kind of handle that? And so my response was, you are correct that no new evidence can be accepted. In this case, the lease was provided as a reference, but staff's position is that the hearing record itself has enough evidence to make the same conclusion. For the actual lease, the Commission would need to inquire with the landlord if this piece of evidence was available at the time of hearing or not. If the Commission finds good cause based on the landlord's answer, they can vote to accept the lease into this hearing tonight. Otherwise, the Commission would move forward with the other pieces of evidence, such as the rent roll showing the deposit amount, etc. Staff feels that it felt it better to provide the document and let the Commission discuss it with the landlord, given that the lease changed the calculations. The other option, obviously you have all the options, but the other option that would be pertinent here would be to remand that on that issue if the Commission finds the evidence is lacking. So that is the response by email today. And then the pertinent issues are staff feels that the garage door should be reversed because they found at the time of the hearing that it was working. There was just this kind of air of potential issues coming up in the future. And the correct determination is whether the housing service is properly maintained at the time of the hearing. And from all that staff could see in the record, it was working at that time, and it looked like it had been working for some time. So we've found that it should be reversed on that matter. And then as to the MAR calculations, I won't go into too much detail. It's a lot of math, and we can discuss it if people have questions. But we did find, based on the evidence in the record, the MAR should be 2635, and that does come from the hearing examiner's evidence. In terms of the rent roll showing the deposit, staff felt that 1 month's rent is typically what the deposit is, and then calculated from there. And so in this case, again, it's to reverse and modify, and I'm available for any questions.
Thank you very much. Commissioners, are there questions? Commissioner Kerpes.
Yes, thank you. I just have one question. In the report, in the staff report at page 15, it talks about staff also believes the hearing examiner erred in the calculations because he subtracted out the $6 registration fee pass through to the tenant. However, landlord never paid that fee. Can you explain this, please?
So what the hearing examiner did is when they were calculating how much should be returned to the tenant, they subtracted out or said that that had been paid, and it actually had not been paid. So because they have to pay that to the city, and they weren't paying that to the city. And so it shouldn't be included in, it shouldn't ding the tenant because it actually was never paid. And so they were subtracting $6 each time to the detriment of the tenant.
Okay.
But that wasn't being paid.
Thank you.
You're welcome.
Thank you. Commissioner Topchin.
Thank you, Chair. Good evening, sir. Mr. Marks, my question is regarding the $40 utility charge. So we are saying that 2,635 MAR includes the $40 utility charge. Would that be consistent with what the RSO says, the utilities, especially if they're paid through RUBS? Would that be considered rent, a base rent?
Yes. So everything that's in the lease is the base rent. We typically are not allowed to break things out, and so it's all lumped together to determine their base rent.
So then follow-up question in that regard, what if the ROBS would increase, let's say, from $40 to $60 at one point? So are we going to say that the MAR is also increasing?
They would only be allowed to increase that whatever the legal increase is per year. So if it's kind of, a landlord has to kind of decide if they want to have the tenants pay it on their own, if they want to pay it. Sometimes there's issues with breaking utilities apart and a flat fee, but if the tenant or the landlord's utilities go up to, 300, the landlord would have to eat that because they can't increase over the increase permitted each year by the RSO.
So then the increase, even let's say, as you said, the ROBS may increase in the future to $300. So the owner can only assess what is permitted under the ordinance, the annual general adjustment to the total amount, regardless of what the utilities would be at the time.
Correct.
Okay, thank you.
I have a question. Page 23 of our packets, both parties in this case, so I don't think this is premature, say that there should be some reimbursement for overpayment. But they ask specifically in the appeal about when they can file a rent increase and if they can include both 2023 and 2024. I know those issues aren't before us, but has staff, I just want to make sure staff has addressed that with the landlord.
There were separate emails that went to the landlord on that topic outside of this appeal.
I just didn't want us to go down that road, so I wanted to just take care of it in advance. Thank you very
appreciate
much.
that.
So seeing no more questions for staff, we will invite the landlord to address us. Let me checking my list here. Jorge Velasquez. And again, please just state your name and city of residence for the record and tell us how you would like to divide your time, and you're welcome to begin at that point.
Hi, good evening. George Velasquez, West Hollywood. I can use up all the time now.
You don't want any time for rebuttal?
No.
Okay, please proceed.
Okay. Good evening. I'm here representing ownership 1043 North Genesee LLC. This is regarding for an appeal filed on 6/28 on our behalf. This was regarding the decision rendered on 6/24 for rent adjustment application Delta 4884 at the site address 1043 North Genesee Avenue, West Hollywood, California, unit number 8. The application initially raised two concerns, one for the non-working overhead gate and one with an issue regarding maximal allowable rent. Our appeal raised questions regarding the evidence used to grant a temporary rent reduction for the non-working overhead gate, as well as the method of calculation for the overpayment. We would like to thank the City of West Hollywood for reviewing our appeal, and we agree with the staff recommendation and hope the commission will modify the decision based on that recommendation. That's it.
Thank you very much. Because you have time reserved, you're welcome to use it later if you change your mind, but I'll ask you at that time. We will now move on to the tenant to make their argument. They have Sarah, I think it's Valleda. Please correct me on the pronunciation, but you're welcome to approach. Again, your name and city of residence, and you can begin.
Yes, my name is Sarah Valleda, and I live at 1043 Genesee, Unit 8.
Could you just pull the microphone slightly closer so everyone can hear you? Thank you.
Okay, Sarah Valleda, 1043 North Genesee, number 8. So the garage was not working from December till March. I was chased out of the garage by homeless people, and I feel like I should not have to do that if that is included in the rent. So that is why I filed that. The overcharges I do agree with, and I accept. However, I have still been overcharged to this month with the rent that they increased illegally. So I do want to state that since June. I have been overpaying as well, and I know this document only goes till May. So I do, I guess I can ask for guidance on that after that, but that's about it for me.
Thank you very much. Does the commission have questions for the tenant? Yeah, our vice chair.
I just wanted to confirm the gate is currently working. It just wasn't working previously in the time you.
Correct, it was not working for about like 5 months.
But currently it is.
Currently it is, yes.
And at the time of the hearing for the application, it was working as well. It was just before that you were reporting from roughly December to March.
When I initially filed it, it was not working, but I think when we had the hearing at the city, they had fixed it.
It had fixed. Okay. And from the period from when it wasn't working, was it the whole time not working or just off and on?
It was off and on, but also for like lengths of time for like weeks when we would put in work orders, it was just never addressed.
Okay. Thank you. Thank you for coming.
Thank you. Any other questions? Seeing none, you're welcome to have a seat.
Okay.
That was it. Mr. Secretary, we have any public comment on this appeal?
No public comment.
Okay, so I'm going to ask the landlord at this point in time if they have any rebuttal. He's shaking his head no, so we will close the public record and open this up for deliberation. And I have a couple questions for staff just right off the bat. One is, what happens when a tenant has an issue at the time of appeal, but it is resolved by the time of the hearing?
There would be no rent reduction. So in this case, the hearing happened after the parties have testified that it was fixed. So there is no rent reduction available there.
Okay. And the next question for you is, I just lost it, so I'll turn to my colleagues.
I want to ask a hypothetical. Let's say at the time of the hearing, it wasn't working, but it had been another intermittent blip of not working. At what point is there a loss in a housing service? And I know your analysis said that the service doesn't have to be performing perfectly all the time during the tenancy. There can be allowances for things when a gate breaks and it has to be fixed, reasonable. I'm just curious if you could give any more guidance on at what point an intermittent becomes continuous enough that there is a loss of a service.
Yep, I understand. So two things, and you'll hear me say this many times, is we don't like hypotheticals because they don't apply to this case, but I'm happy to answer this one because it does come up. And so the standard is a substantial reduction in a housing service. Here, I don't think that even if there was the blips as you speak of happening, they don't sound like they, in my opinion, apply to this case. There could be, and I think probably people that have been on the commission for a while could probably dig through our memories to find cases where it does work, but it's, it's 80% working, 20, and that's a determination for the commission to make, whether that is a substantial reduction. If it goes out once a month, I don't know if that's substantial, and so if those facts came before you, it'd be for you, the group of you to discuss and decide.
Commissioner Thompson, you had some questions?
Yeah, just want to clarify, this is for the legal counsel, Mr. Martz. So you said that there are no rent reduction now and going forward, clearly because it's been fixed, the garage door. But what about the $50 monthly since the decision was made in June until now?
For the garage door?
Yeah.
So no, because my staff's recommendation is that the hearing examiner erred and that they shouldn't have made that determination that it was a reduction in services.
Correct, yeah. Thank you.
Mm-hmm.
Any other questions? Can you point me to where in the established record, since because we didn't ask the landlord about the lease, both parties said that they were fine with staff's recommendation, so I didn't raise that question with the landlord, and we've closed the public hearing now. Where in the established record for the hearing examiner would they have been able to determine that and it's probably there, and I've just missed it, but they could determine that the original rent was $2,635.
Sure, of course. And so it's a little bit of a difficult task. So staff is operating under the assumption that almost all leases, the deposit is 1 month's rent. And so in the rent roll, and I'll get you a page number in a moment, where it shows all the units and the different parties' names and whatnot, it shows the deposit was $25.95, and then if you add the $40 utility charge, then that would go to the $26.35. And so that was where we were basing that off of. You'll have to forgive me while I scroll through, but if someone finds it first.
Yeah, I'm open to anyone showing me that because I just am not finding it myself.
I think it's page 67 of the packet.
Okay, I'm seeing that on the rent roll, but it says $25.95. I'm not seeing the additional $40 to calculate that number.
Correct. So the $25.95 is their version of rent, but there's the $40 rent charge. And then also I believe we have rent payments from the tenant that were submitted separately, that were bank statements that show $26.35 being paid.
Okay, and as Commissioner Rory's pointing out to me from page 67, I see that now. Thank you, I just missed it.
Great, thanks.
Any other questions, or would anyone like to begin deliberation?
I'll start. I appreciate the tenant coming tonight, and I can imagine how nerve-wracking and scary the gate outages were. The legal analysis is what's the status of the service at the time of the hearing, and it was working, albeit it took a while to get fixed, apparently from the record, but based on that, I would affirm on the gate because it did get fixed, although there were a number of attempts to make it work, and I'm sure that was nerve-wracking while it wasn't working. And then on the MAR, it seems like staff got to the bottom of it and determined that 2635 was the correct number and did the math to readjust what was overpaid. So I felt comfortable with that as well, and I would move to affirm on both issues and the appeal itself.
Thank you. Commissioner Topshin?
Okay, thank you, Chair. Very quickly, I believe that staff's analysis of the hearing examiner's decision is correct in regards to the recommendation to reverse the decision as to the garage door matter, and I agree with staff's recommendation to modify the decision of the hearing examiner as to the MAR determination and rent overcharge calculations. Thank you.
Thank you. While I'm at this side of the dais, Commissioner Parrish, do you have comments at this time?
No, not at this time. Thank you.
Thank you. Any Commissioner McCafferty?
Yeah, I also agree with staff's analysis. With the garage, it seems like it might have taken the tenant going to the commission and going through this process to get that response and get the garage fixed. So I encourage in the future for the landlord to be more diligent on these, and so you don't have to come here to use this as mediation. Like not letting it get this far. As far as the MAR, I also agree on staff's analysis. It seems they got to the bottom of it and figured it out. So I'll affirm both.
Commissioner Kerpes, we'll go down the line.
Yeah, I think I'll be in the minority here. Obviously, I'm in the minority here. I disagree that this is just a on and off thing. The tenant testified about the effects that the garage door not working has had on, actually both tenants did. And I'm looking at page 87, where there's a kind of a listing of, 12.7, garage still won't close, please fix. 12.8, garage still won't close. 12.8, per lease, garage door, if any, shall be kept closed. 118, garage door is still open, needs to be fixed. 119, still open. And then it has a requested by you on 12/4/23. This request was completed on 3/5/24. Whether it was request on 12/4 or 119, it seems that the request was completed on 3/05/24 in response to that. If you look at the other documents that the Drake Real Estate Group put in, we're talking 3 or 4 days, and I understand that that is a probably a reasonable time to respond, but there comes a point when you have to replace the item that isn't working properly. So I disagree that the hearing examiner erred in their decision. I think that they were the one that heard the facts, and I agree with them. I do agree with staff's recommendation or staff's interpretation and recommendation that that the hearing examiner erred in the dollar amount. That was a mathematical error, and the other errors that they mentioned about the $6. So I would agree in part and disagree in part. I support the hearing examiner in the reduction of rent, and then obviously the overpayment would need to be recalculated.
Thank you. Commissioner Goldman.
So I actually agree with Commissioner Kerpes on the garage door issue, because given those dates, that's more than just a short blip that service is out. So I do think some compensation is in order, although I guess my question is, are we limited only to at the time of the hearing that it's working or not working, nothing prior? That can't be taken into account? Is that correct?
Correct. So the hearing examiner is determining on that date they meet in the hearing office whether it is working or not. And so you can't reward for past misbehavior, misdeeds, and one of the goals of the commission and the RSO and the regulations is not as a punishment, but as to actually get the landlord to fix the thing that needs to be fixed. So it's not a backwards punishment.
Okay, so yeah, so given that, then I suppose that I do agree with the staff's decision, just based on the legal aspect of it. But I would, I guess, encourage it because it's an unfortunate situation. So I would encourage the tenant, to come back, and if this is happening again, and encourage the landlord to fix things and replace things so that everyone doesn't end up here.
In that case, can we recommend that lifting that 6-month waiting period if the issue comes up again, so the tenant can refile?
Yes, you have that right. I think I've mentioned it before, but that should be used sparingly. And so and that's what the regulations say. It's supposed to be an exception. So it shouldn't be a regular thing. We shouldn't be, we like the tenant and we're, those type of things. But it does date back to the hearing date. So I don't have that specific date, but, we're quite a ways past that. So a few more months till they would be able to file already under the ordinance.
Yes, Commissioner Kerpes.
My question is, so based upon the analysis that was just provided about the date of the hearing and whether it was working or not, did I understand correctly that, so on the date of the hearing, if the garage door was working, no reduction could be made?
Well, going back to the hypothetical that I don't like is if you found that it was working on that day, but that was a small time and that it would continue to not work. Staff does not see that situation is applicable here. I think the testimony tonight and the evidence in the record was on the date, and since then it's been working. We haven't really heard anything otherwise. But yes, if it was working on that day, but the tenant had testified that the hearing's on a Wednesday and they're like, it goes out every Thursday, then maybe you could find it. But I don't see any of those facts present here. But the commission makes those decisions.
So yeah, let me ask the question again. Based upon this case, the hearing was held on May 13th, 2024.
Correct.
Are you saying that if and obviously it was a complaint filed on March 21st, you're not saying that just because it works on May 13th, the hearing examiner can't issue a...
Correct. I'm just saying the facts in staff's recommendation don't support that in this case. So, okay. And I think it was testified tonight that it started working in March.
But the evidence shows that it didn't work which is equivalent to her testimony in the case, that it didn't work for a couple months starting in December through March.
Correct. But if it is found to be working and the hearing, and you find that there was not a substantial reduction in services, then there wouldn't be a rent reduction.
Of course.
That's for the commission to decide.
All right, thank you. My position remains the same.
Commissioner McCafferty.
I have a question. Given that there's repeated requests to fix this garage, either within like our jurisdiction or just like a jurisdiction of the code, it seems like there's like a faulty garage door happening. Is there any code supporting or requiring the landlord to replace this garage, or can you have a garage door that breaks down monthly and that's fine as long as you're fixing it?
I mean, it could be code enforcement that goes out there. They do a lot of building things. I don't know specifically if they do garage doors, but I have used code enforcement on my gate, which is similar to a garage door, and they have come out and assisted on that. It's rare that code enforcement will, especially in the first place, demand that it be replaced. But this is a little bit outside of the jurisdiction of the commission here.
Okay, so it's going to a place of like building zoning code outside. Okay.
Yeah, we do have other departments that can be called instead of a rent reduction request.
Thanks.
I would like to weigh in, and I concur with Commissioner Kerpes in that we see the record of it not working in December and in January, and then the landlord says that was completed on March 5th, yet the hearing was applied for, the application for this hearing, March 21st. So 2 weeks later, the tenant is saying it's not working, and they signed that document saying it wasn't working 2 weeks after the landlord said it was fixed. My concern is that it might have very well been working, and based on the record, it appears that both parties agreed it was working on May 13th, but that the hearing examiner, by a preponderance of the evidence, found that it was a faulty door that was a reduction in a housing service, and therefore felt like it needed to have a better resolution, is how I'm reading this. So I concur with Commissioner Kerpes. And as far as the MAR, the maximum allowable rent, I was just as confused as I believe that the hearing examiner was by the evidence before us, and required other people to look at it at a different way. So I do believe the hearing examiner erred on that, and staff got it right. So that's where I am, and I would be where Commissioner Kerpes is. So I think there's a majority on the commission for one position, and so I would like to see if anyone wants to make a motion to that effect, or if there's more deliberation.
Okay. Go ahead, Vice Chair.
On the garage door, just if that's the issue that maybe there isn't a consensus on, I did look at this a little bit it seems to me in the printed record on pages 95 to 109, there's a series of invoices that were submitted for the repairs. And one of the things that I noticed was that each repair invoice was for a different problem. And I did hear tonight, there was and there might be a concern that the same issue just kept happening over and over. And at what point are you supposed to have the same issue happen over and over? But I don't think that's what's in the record here. If you look at these invoices, they're all different issues. Now, does it stink that the gate stops working because there's a water problem one time, and then a sensor issue the other time, and then a motor issue another time, and then a different issue the fourth time? 100%. But even on the invoices themselves too, it seems to me they have some description of when the issue was reported and when it got resolved. And I'm not seeing that this was a continuous problem. I'm seeing it was like a repeated problem over 4 months, and it seemed to have stopped in March. And when the hearing happened in May, it was no longer an issue. And at that point, the hearing examiner made a determination, is this a substantial loss? And based on the evidence that I think was in the record and that I'm assuming the hearing examiner looked at, I really don't think, I think that the hearing examiner, I think that staff's recommendation is correct, where this isn't substantial loss. This was 4 or 5 times over a couple of months for a bunch of different issues that did get resolved and had been resolved at the time of the hearing. So if there's a splinter on the desire on the gate issue, I would strongly oppose that and encourage adoption of the staff recommendation if that's where this is going.
I have one quick question.
Please.
With the issue of it got fixed before, it got fixed before the hearing or it got fixed before they filed? The March or the May date is what I'm looking at.
The main date that you should be focusing your attention is the date of the hearing, what was happening on the date of the hearing. Obviously what happened before you look at, but if something, if in an easier case, if the argument was they took away my, pool chairs and they put them back, that's pretty black and white. This one's not as black and white, but it's the date of the hearing.
Okay, so that's May. Okay, thank you.
Real quickly, now come to Commissioner Kirby's. Going back to the question of, is it the date of the application or the hearing? So it costs $25 or a fee waiver to apply for a rent hearing examiner. So what happens? Okay, so I have an issue with my apartment. I file for a hearing, and the landlord goes, oh crap, I'm gonna have to go to this hearing. And so they fix it, even though I've been asking them and asking them and asking them. I had to pay $25 now for them to fix that. So I don't get the rent reduction, but does the hearing examiner give me my $25 back from the landlord? Because I shouldn't have to pay to get my landlord to do something, even though they win on the...
I don't think you'll like the answer, but I want to defer to staff if they know.
Generally, we see the repayment when the decision is in favor of the tenant, in this case, landlord would pay it. I would imagine that, speaking hypothetically though, if the decision were not made in favor, if it were withdrawn, that requirement wouldn't be imposed to repay the $25. Assuming that there's no rebate, like you were mentioning, for having lower income and things like that.
Right, and maybe it's out of place because that doesn't apply here, because they would have succeeded on the merits on the MAR regardless. I think that's where this commission's headed. So not to jump the gun on that one, but I've heard 7 of us say the same thing. Well, 6. Commissioner Paris, you didn't speak up, so I don't want to put words in your mouth. I'm sorry. So it doesn't apply here, but it just seems like a problem for me that we're siding on behalf of a landlord in a hypothetical case, but the tenant has to pay $25 to get the landlord to do the work. But so I have a problem with that timeline, but that's for me to work through in my own head, and I'm sorry I wasted all of your time with that. Commissioner Topchin.
Just probably a quick comment that the reason why I agree with staff's recommendation is because we, as a commission, we're not in the business of getting reimbursed for sort of damages for the gate that was not functioning prior to the hearing. So otherwise, we're going to be acting like small courts. So we cannot do that. So the fact remains is that as to the date of the hearing, the gate issue was resolved. So what happened prior to that, all the damages, repairs, or whatever it is, will be irrelevant at that point because it's confirmed that as of May 13, the issue was resolved. So that's why the examiner erred, and that's why I agree with staff's recommendation. So we have no choice but basically to stick with that date. As for what happened prior to that, if the tenant has the option to obviously disagree with the staff's with the commission's decision tonight, if the decision will be in favor of the staff's recommendation. So the tenant may seek legal, may pursue reimbursement in small claims court for the time that the service was unavailable, but we cannot do that. So, thank you. And whenever it's time, I'm prepared to make a motion.
There are at least two more comments. Commissioner Kerpes?
Yeah, just to respond to a few things that have been said. Excuse me. So when I say the same thing, I'm talking about the same service that's being lost. And it's the service that's being lost here is the ability to lock the vehicle in the garage, in a secure garage. And just like in other cases where, it doesn't matter whether the city tells you to take away the parking spot or whether you've taken away the parking spot, to the tenant, it's the same thing. It's a loss of a service. It's a loss of a parking spot. So, yes, it is unfortunate that there are different reasons why this garage door doesn't work, but it does not work on a regular basis. And if you look at what I'm saying is that I'm not saying that it doesn't work every day. I'm saying, and I don't think the tenant's saying that. I think the tenant is saying that it doesn't work all the time. It doesn't work regularly. It sometimes works, sometimes doesn't. And when it doesn't, if you look at page 95, we're looking at about 14 days that it didn't work, at least according to this invoice that Drake Real Estate submitted. So we're talking about, and then the other cases like 3 or 4 days. And usually, just a reasonable person would assume that it's usually the morning you come out and you realize, what's our garage door doing open? So I'm going to report it that day when I realize it. That doesn't mean that it wasn't working the day before, or that it was working the day before. It's just when it was reported. So then it takes the landlord 2 or 3 days to responsibly, it looks like they were responsible each time, and they did what they needed to do to have it repaired, but it takes 3 or 4 days. So again, the service is what's being lost here. And the ability, and on May 13th, the knowledge of when I'm talking about the hearing date, even if they both agreed that yes, the gate might have been working on that very same day, doesn't mean that the tenant has confidence that it's going to work the next day or the day after that. And that's what this tenant claimed from the very beginning. They moved in because the garage door locking was important to them. And that's the service that's been lost here. And I just want to say we should be very careful this is not a punishment towards the landlord, but what I'm saying is we should be very careful in kind of what Chair Bass brought up is where we have situations where I'm required to give my landlord 30 days notice before I can file a hearing. So I tell my landlord, paint my apartment, it's overdue, please do that. And I have to wait my 30 days before I can file a claim. So I wait 33 days. And I go to the city hall and I file my hearing, file for a hearing. And I still have to wait, 2 or 3 days. I have to, let the landlord know. that has to be scheduled. And then it just so happens that by the time that I finally get my hearing, my apartment's painted. So I've gone through all this work. When landlords should respond to the 30 days or not. I mean, we shouldn't punish tenants for having this drag on and on and on and on, and landlords taking more than 30 days to repair something. So I'm just saying, be careful about just making a hard decision on whether something was fixed that day or not, because I think Chair Bass brought up an excellent scenario.
I see both my colleagues to my right also pressing for their buttons. So go, Commissioner McCafferty, can come back in this way.
Just a quick, I agree with what Commissioner Kirby's brought up.
Could you please use your mic?
I agree with what Commissioner Kirby's brought up. It's just my quick comment.
Commissioner Goldman?
Yeah, I agree as well, and I think that given all the evidence of it working, not working, working, and what the tenant is saying, I think maybe we don't know if it's working, if it's just working that day. And so I'm wondering if we can, I mean, the landlord can request a compliance determination from the city. So if we were not to overturn the hearing examiner's decision, the landlord would be free to do that. Is that correct?
Okay, and I don't want to beat a dead horse here, but I'm going to add in one more thing, and that is, it does not matter what we think about how the garage door was working. That is irrelevant. What our job, I believe, is to determine if the hearing examiner had enough evidence to believe in making this decision. And the hearing examiner, on page 76 of our packet, page 6 of the decision, second to last paragraph in the middle, it says, there is no consistency to the functionality or operation of the garage and tenants' belongings have been stolen. So I believe that they were acknowledging that it might be working that day, but we're applying this rent reduction for the lack of consistency and functionality. And so with that, I think there might be a different majority now. I think we might be ready for a motion, but it might even require legal counsel to rewrite something, I'm guessing. Anyone want to take a stab or have more comments? Commissioner Topshin?
My motion is to affirm the staff's recommendation.
Second.
We have a motion and a second on the floor. If the secretary is ready, we would like a roll call on that.
Commissioner Goldman,
No.
Commissioner Kirpies,
No.
Commissioner McCafferty,
No.
Commissioner Paris,
No.
Commissioner Topshin,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
No. The motion fails, 5-2.
Chair, I'll make a
Alternative
motion.
Commissioner Kirby's.
I'll move to affirm the hearing examiner's decision on the rent reduction for lack of services, or reduction in services, and and to basically go with staff's recommendation on the MAR, the recalculation of the MAR, the correct calculation, and that the hearing examiner erred on calculating the MAR, and I would affirm staff's decision or staff's recommendation on
I
the MAR.
think that motion is clear, but will require new language. Let's get a second before we move on.
I'll second it.
With the second, does staff have enough to write that? I have a sneaking suspicion that the next appeal might take a little while. So would it make sense to take a little break now for you to write this and then get back to business?
Yes, that would be fine.
Okay, so here's what we're going to do so everyone understands what's going on. We're going to take about a 5-minute break so the attorney can rewrite some of the language for the resolution, and we can then vote at that point in time. I would instruct the commission not to have any conversations outside of the public to make sure that we're completely transparent. So no discussions about this case or anything before us tonight, and we will be back in about 5 minutes and actually take a vote on this motion. We're ready to proceed. So what we're going to do here, I'll ask legal counsel to read this language into the record, and then I will ask commissioners if they have additional questions, and then we will proceed to a vote at that point.
Great. So everyone has the draft resolution for D-4884, and I will just note the changes to that into the record. So the title of the document now reads, "A Resolution of the Rent Stabilization Commission of the City of West Hollywood affirming in part and modifying in part the hearing examiner's decision as to application number D-4884. On page 2, section 4, it now reads, "The commission finds that the decision is not in error and is reasonably supported by the findings made and evidence in the record as to the garage door. The commission further finds that the decision is in error and is not reasonably supported by the findings made and evidence in the record as to the MAR and rent overcharge calculations. The commission hereby affirms in part and modifies in part the decision on the following basis." And then on page 3, paragraph 1, the commission finds that there is sufficient evidence of an ongoing issue with the garage door at the time of the hearing. Therefore, the commission affirms the hearing examiner's decision on the $50 rent decrease for this issue, as it meets the standard for a substantial reduction in services warranting a rent decrease. And those are the changes.
Thank you very much. Are there questions for the commission, from the commission at this time?
I had one follow-up question on the amended resolution. So if the hearing examiner's decision is restored on the $50 rent decrease for the gate, and now the landlord has to go and apply to have a restoration in service, a hearing determination for restoration in service, whenever that hearing or application actually gets heard, can you remind me what the hearing examiner's options are at that point in terms of looking at the evidentiary record and saying, okay, let's say there's an application filed in November and there's a review in December of 2024. Can they go back and say, well, as of March 2024, the issue seems to have been resolved, or does the rent decrease enlighten me on how far the rent decrease is going to apply, including into the months where the evidence is clear and unrefuted that the gate is currently working and has been working since March?
Yeah, so if the commission decides that the hearing examiner is correct as to the $50 reduction for the gate, the compliance determination would be filed and the rent reduction would go through the time of the hearing examiner's decision or the department's decision on that compliance determination. So it would continue for the foreseeable future until that is filed and determined.
And then on comment, I just think that's a terrible result. If the gate's been working since March and there was a period from December to March where it wasn't working, and this commission wants to do something about that, that's fine. But from March to November, to say we're going to have a rent reduction for a gate that we know is working, that's a real problem, and it's a shame if that motion passes.
Chair.
Commissioner Kerpes.
Legal counsel, is it correct that the existing order would remain, and the order is repair the garage so that it is good working order, so that it is properly closes when not in use? If repairs are not possible, the landlord shall replace the old garage door with new functioning garage door that properly closes when it not in use. If completed, will restore $50 of rent. Based upon our resolution, in the previous decision, I think that should give the city direction on what the order is.
Correct.
Thank you.
Commissioner Paris.
I want to ask this, and it may fall out of scope, but my understanding based on the evidence that's in the record is that there were underlying issues surrounding the function of the garage door, the leak or water damage and the ceiling falling, etc. We can't rule necessarily based on those issues, but can we ask compliance to take those into account when they're inspecting?
So compliance determinations, it's however the department and the hearing examiner wants to make that determination. So that's their purview of how they will determine whether the issue has been fixed or not. But generally, they look at the full record from the hearing, from whatever happens in the commission, and take all that into account when they decide how to address it, whether it's through an inspection, invoices, staff visit, anything like that, and then how they determine the response as well.
Commissioner Paris?
Yes.
Okay. I wanted to ask one question, and that is, so the appeal was filed on July 1st. Isn't it true that the landlord could have simply filed a compliance determination on July 1st saying that the door is working, and then there would have been a compliance determination at that point in time?
I'm going to defer to staff. I believe that it's one or the other.
Right. I'm suggesting one or the other. They could have taken that
Correct.
approach as opposed to an appeal.
Yeah.
And then we wouldn't be having this. We might have been having this hearing on the other parts of the decision,
Correct.
but they could have gotten a compliance determination on the.
You want?
Yeah, that's correct. They could, at any point following the reduction, once the service is restored, they can file for a compliance determination.
Okay, so they could have stopped at $50 earlier with a compliance determination, or around the same time as we're sitting here now.
If it had been granted, yeah, at that point, the
Right.
reduction.
Assuming a granting.
Yes.
Right, which is not necessarily sure, but was an option. Okay, Commissioner Topchin.
Just a quick comment, I guess, and maybe a question. I agree with the Vice Chair's comment, so I think if this motion passes, it will be an unfortunate wrong decision, but would this become, would this, if it's passed, would that set sort of a precedent for all future similar like cases?
No.
All right,
No.
Thank you.
Commissioner McCafferty.
Just before we vote, and hopefully wrap this up, I wanted to bring light to the tenant's question about how she had been paying her old, like not approved increased rent since this summer. So I just wanted, I know, to give her some guidance on even just like who to ask or who to
Yeah,
contact
so
about
that's outside of the appeal tonight. That should be directed to staff, and we can provide that number. Or the appropriate thing, I think, would be the landlord to kind of just take it into account and fix it based on this decision, but it is outside the scope of this appeal.
Thank you. Anything else? Then I will ask the secretary to call a roll.
Commissioner Goldman,
Aye.
Commissioner Kirpies,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topchin,
No.
Vice Chair Rory,
No.
Chair Bass.
Aye. The motion carries. Then I have something to read here. Let's see. Sorry, lots of paperwork tonight. So the motion passes, and if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. We will now move on to our second appeal for this evening, and that appeal is number 4877, and it is for 917 Larrabee Street. And at this point, we will ask for a staff report, but we'll follow the same sort of procedure as we did on the last appeal.
Great, thank you. Good evening, everyone. My name is Kellen Martz, legal counsel to the Rent Stabilization Commission. This is an appeal for D-4877. In this case, the questions before the commission is whether there's been a substantial reduction in housing services that warrant a rent decrease under the Rent Stabilization Ordinance. The tenant has lived at the property since 2017. The tenant filed for a rent decrease in May 16th, 2024. And the hearing examiner, after hearing the testimony and evidence, found that the tenant was entitled to a rent decrease of $1,551.25 for the reduction in housing services. That applies to all tenants except those who opted out, since these are common area issues. The application requested 13 different topics to be discussed. I'm going to defer to the staff report for those since they're lengthy. And And then in the decision, the landlord found that 12 of those had been proven by the tenant or the tenants that came to the hearing, the neighboring tenants. And the only item that was found not to have been supported by the evidence was the alleged drug use and drug dealing concerns at the property. And so the landlord timely filed an appeal, claiming that the decision was clearly in error, not reasonably supported by the findings or evidence in the record, contrary to the specific provisions of the RSO, and that it was an abuse of discretion. The main arguments from the landlord are that there was good cause for continuation. They did make a request to continue this for a second time, the May 16th hearing, because the resident manager was the most knowledgeable person able to address the issues. Before the hearing examiner was not impartial because he only had the tenant's testimony, since no one from the landlord's side showed up, and there needs to be more evidence than just the tenant's word. And then in the staff report, I will defer to the specific issues they find with each of the common area issues. Staff finds that there is substantial evidence supporting the hearing examiner's decision regarding all of the 12 issues, and also correctly on the 13th issue of the no evidence of the drug use and dealing. And then briefly, staff wants to explain the continuance issue, because we don't deal with that very often here. There was a first continuance requested by the landlord, and that was granted. There was a second continuance requested. Staff explained that they would go forward. The RSO requires that efforts be made to discuss a request for a continuance with the tenants, and to document what efforts were made when making that formal request with the city. On the second continuance request, that was not done by the landlord. So we don't find that there was good cause to continue that. There's also some contradictory statements by the landlord of whether there was someone available to go. They stated that the person most knowledgeable was the resident manager, and they were in the hospital, but then they also stated that they did have a backup or temporary resident manager who could have, that was helping fill those duties. So it's 601 half in it as the other. You can't say you have a resident manager in compliance with our laws and then say they can't attend the hearing. That's staff's position. And then the municipal code, the RSO, and our regulations do permit a hearing examiner to make a decision based solely on direct testimony. And just briefly, direct and hearsay. Direct is said straight from the person who has the knowledge of the topic. Hearsay is, I heard someone say something about something else. It's an out of hearing statement. And so that is what the hearing examiner found was the problem with the drug use argument, was that the tenants had heard something or said, someone else had said something, and so that's why they ruled against them on that issue. But our regulations allow a decision to be made solely based on testimony. They could potentially win a case without photos, without emails or anything like that. Obviously, it would be more difficult, but it is permitted under the regulations. So in this case, there was the tenant, there were two neighboring tenants that provided testimony. There were various photos, emails, and those type of things to support the hearing examiner's decision. So we do not find that there was error there or any issues with our regulations or the law. And that concludes my report.
Thank you very much. This one's going to be a lot of different items, and so I'm going to try to move this conversation along in an orderly way, and feel free to help me with that as well. But are there questions just specifically for staff about the staff report at this point in time? I don't see any, which is, I think, a first. With that, we will move on to public testimony. Like before, we're going to start with the appellant. That's the landlord's representative. I have Damon Kirsch, I think. And when you approach, just state your name, city of residence, and how you would like to split your time. You have 5 minutes total.
Yes, my name is Damon Kirsch. I reside at 917 Larrabee Street. I'm here as a representative of Rich Bonvino, who is the building manager and was taken to the hospital at 6 p.m. this evening by ambulance. So I have his notes here, which I'm going to read.
Could you just tell us
verbatim.
how you'd like to divide your time, and then we'll start your timer?
Since I'm really not in any position to speak on his behalf other than to read his written statement, I will just use the time now, and
If you have time remaining,
I'm not authorized to rebut.
you can choose whether to do rebuttal at that time or not.
Very
Thank
good.
you very much. Please proceed.
So he has here a list of 13 of the 13 issues and his responses to each of them in turn. Number 1, regarding the washers and dryers, he states always working, repairs and replacements are made as needed. Number 2, structural cracks. There's nothing to indicate that in the foundation, the port foundation, there is anything to raise any threat. And throughout, I should mention, he lists an addendum of photos, which I do not have with me right now, but I know he has in his possession. With regards to number 2, he says, see photos. Number 3, mold in common areas. He writes, there are none, there is none. Number 4, he leaves no comment. Number 5, camera installed. These were for the building's use only. For number 6, dirty common areas and walkway, he writes, rinsed down twice a week and checked on a daily basis, see photo. Number 7, dirty pool. Pool is cleaned, maintained weekly, and any extras as needed, see photos. Number 8, regarding dead plants and bugs, there are none. Plants or bugs weekly treated by gardener and exterminator, see photos. Number 9, building-wide plumbing issues, he writes, taken care of as needed. Number 10, resident manager, Rich Bonvino, 20 years experience. Number 11, storage under stairs, there are none. Number 12, keyless entry, the code is given out, see photo. Number 13, roof leaks, a new roof was installed, see photo. That's the end of his comment.
Thank you very much. Mr. Secretary, how much time does he have remaining? The button sticks sometimes.
3 minutes and 11 seconds.
Thank you. We will now move on to the respondent. That's the tenant. I have Mary Kate Liebman. You will have 5 minutes.
My name is Mary Kate Liebman, and I am a tenant and resident of West Hollywood. I want to say that I support the hearing examiner's decision to reject this meritless appeal in its entirety and grant the reduction in full. Instead of paying money to fix the numerous issues brought to the hearing, the landlord has chosen to pay for an attorney to gaslight and perform character assassination on both renters and the hearing examiner. Evidence is overwhelmingly with the tenants, and it is not limited to hearsay or tenant testimony, but notice of violations, pictures, emails, well over a year. The city itself has evidence in its possession, and tenants continue to face these declines in services to this day, as well as harassment and a continued denial of repairs. Today, Mr. Bonvino is the registered on-site property manager, and he has produced a medical emergency on the first hearing, the second hearing, and in just the last week, avoided a deposition scheduled on November 1st with a medical excuse in unrelated litigation. Today, only an hour ago, Mr. Bonvino was escorted by ambulance to the hospital for another medical episode, and I do believe I speak for all tenants here and those not here presently when I say that we hope he makes a swift recovery. However, this manager does have serious health issues, which was brought to the attention of the hearing examiner at the time in April and in May. And this leaves tenants without on-site management as required by the city. And this often occurs without any notice to tenants. And while we sympathize with these issues, we need reliable on-site management or designated assistant management to deal with these issues. When it comes time to review compliance, we hope that the city must exercise extreme skepticism and be thorough in its analysis based on past conduct at this property. When investigated for conducting an illegal Airbnb in numerous units at the property, Mr. Bonvino, the on-site property manager, at the behest of ownership, provided code officers with fraudulent leases, passing off Airbnb guests as tenants. The same lawyer who has written a lengthy and insultingly improper appeal in this case was also instrumental in creating a fake document which annulled this fraudulent lease. Because of all of these efforts to evade responsibility, even committing fraud in the process, we urge extreme vigilance and tenacity in enforcing tenants' rights at this property. This landlord has pocketed $350,000 in rent overpayment since April 2024. That amount could solve every single issue outstanding and then some. And I would like to reserve the remainder of my time for rebuttal as necessary, but
I apologize, you cannot have rebuttal.
I cannot have a rebuttal. Okay, then I will make
That's just
my
by
final...
our policy.
Thank you, okay. So, as I said, that amount could pay for every single issue outstanding, but then I would like to conclude with these 3 points before concluding today. Number one, I hope that the commission will grant tenants immediate relief in the form of clear instructions for rent reduction. We've gotten a lot of confusion from tenants, and we don't want tenants to overpay when it comes to December should this decision stand. Management has made no effort to provide information about the appeal, the hearing, or anything required by city law and regulations to tenants. It's rested on the Tenants Association to do that. And so we worry that people may mistakenly overpay even if this reduction is granted. And we hope that, if these conditions are not met, the city can and should also consider receivership if they are still not willing to fix these issues. They have made no attempt to do so. They have provided no evidence in their favor. And so we believe this reduction should stand in full. Thank you for your time and consideration.
Thank you very much. We now move to public comment. And, excuse me, I should ask if there are any questions for the tenant. I missed that part.
No questions, but I think the landlord had some time for the rebuttal, or?
Yes, but we do public comment at this point per our bylaws, which our secretary looked up for us. That's how we're supposed to proceed. Thank you.
Chair, I didn't mean to correct you.
No, thank you, because
I had a question for the landlord.
This is a confusing process sometimes, and I'm fairly new at this, but Commissioner Kirpies. No questions for the tenant? Okay, we will now move to public comment, and I believe we have several folks in line to speak. The first would be Raphael Gamon, I think. Please forgive me if I mispronounce your names. And then you'll be followed by Sean Barber, and you'll have 3 minutes to speak. Please proceed.
My name is Raphael Gamon. I live at 917 Larrabee in West Hollywood, California. Ladies and gentlemen of the Commission, a lawyer holds a profound moral obligation to embody honesty and uphold the ethical rules guiding their profession, especially when aware that their client is not truthful. It is under these circumstances that I present my case for an immediate implementation of the rent deduction before you. Mr. Ira Katz, the attorney hired by Greg Segal, has in the past defended forged documents submitted to the City of West Hollywood Rent Stabilization, Fully aware, he attempted to defend his client's lies and since took no steps to correct this error. Falsus in uno, falsus in omnibus. To this day, our landlord ordered his managers and lawyers not to submit a listing of all tenants in our dwelling as requested from the city in May 2024. This resulted in a rent deduction granted, appealed, and re-granted to stand in full for all units in our building, inclusive 2 unoccupied apartments. Today, I address only issue number 12 concerning the gate code access to our building, underlining the unreasonable measures taken by management, ownership, and their legal hand. They have engaged the same lawyer to craft an elaborate 11-paragraph responses in the violation. In the awkward appeals document, rife with insults and falsehoods, instead of providing proof of fix and amending the orders, Mr. Katz's lengthy response, 11 paragraphs about the $43 rent deduction granted to all tenants, is due to Manager Bonvino revoking gate code access last year. Rather than spend 2 mere minutes to re-provide this essential gate code to all tenants, as Mr. Ira Katz himself recommends in July 24th on the appeals response, ownership instead chosen to risk $10,000 retroactive rent deductions to needlessly punish everyone residing in our building. Illustrating further disregard, yesterday morning, Mr. Bonvino posted a handwritten note in the laundry room with the passive-aggressive message that reads, "For those interested, the code in front gate is so-and-so." Astonishingly, this comes $10,000 late, a mere day before this commission's final hearing, and 4 months post their own lawyer agreeing that all tenants should have access to the gate code. By displaying this code in a public space, it allows access to any visitor, contractor, and stranger. This follows a concerning pattern. Initially, Ira Katz threatened tenants that in the appeals letter, as you can read, claiming we'd be liable for any misuse of the code instead of management routinely changing it, as practiced in any other building on our street, and informing legal tenants privately. This point alone expresses and encapsulates the broader dilemma we deal with. Please, dear members of this commission, in the absence of any efforts to fairly amend the many serious fixes and the outstanding penalties owed to the City of West Hollywood resulting from an illegal Airbnb attempt, grant us a receivership until our basic living conditions are up to code and help protecting tenants from further abuse. I yield my time.
Thank you very much. Mr. Barber, and then I have no one else. If there's anyone else who's going to speak, please say our secretary.
Whenever?
Yes, just your name and city of residence, and you can proceed. 3 minutes.
My name is Sean Barber. I live at 917 Lowry Street, unit number 10. The first thing that I'd like to do is just speak on behalf of our current resident manager, who is Rich Bonvino. He is a friend of mine, and I fully support him staying on. I've never had an issue with him. I think he's a wonderful manager. I think he does a lot for the building. I think his hands are tied because the landlord doesn't want to pay for anything. But I think he really goes out of his way to try to take care of the tenants and do creative and things around the building. My issues have never been with him. So when I was at the last hearing, anything that I stated, it had to do with Greg Siegel and bad decisions made by the previous manager, Linwood Porter, who's also a friend of mine, but unfortunately I have to be honest in this case. So nothing that I ever stated was ever against Rich Bonvino. I support him as manager. That being said, if I can just be candid, the problem here is that Greg Siegel, ever since he inherited and took over being landlord of the building, he's just cheap. He doesn't want to pay for anything. Whether the tenant is just entitled to it, or whether it's a health hazard or a safety hazard, he just doesn't want to. I've had to deal with him on my own. I fought with him for 2 years over flooding of black sewage water, because the pipes apparently crisscross with each other. In my apartment, ruined my floors. My apartment smelled like a sewage tank for 7 months. It took 2 years of fighting with him. I went through City Hall. I did everything I was supposed to, and I received a rent reduction. And his response was, "Well, you can keep the rent reduction because that's cheaper than if I pay to replace your floors." And by the time the rent reduction adds up to the cost of replacing the floors, it would take 30 years. At that point, I threatened to sue. At that point, I got results. My floors still aren't fully replaced. This is from 2017, but the point I'm trying to make is that this landlord on numerous occasions has made the comment that he'd rather pay the fine, pay the rent reduction, he'd rather take whichever option saves him money, even if it means violating code, breaking the laws, not upholding his responsibilities and duties as landlord. He has no problem collecting our rent checks, but if you want things done, you have to really fight to get it done. Now, Rich Bonvino, in my opinion, the current manager, does go out of his way to try to help out as much as he can, but there's only so much that you can do. The previous manager, again, a friend of mine, I don't know what his problem was, but even if things were approved for me, he wouldn't let me have it. Like, he would never let me have a complete paint job. Didn't want to do my ceilings, didn't want to do the doorposts, because he said he didn't feel like it, which I don't know why. He's not painting it personally, but the point I'm trying to make is that this has been a problem for years before the current manager stepped in. And there's just things in the building that are just old and need to be replaced. Like, the washing machines. I think we're the only building that still has coin operated only washing machines. Everyone I know, it's all card now. So
Thank you.
Is that it?
You're done with time, but I just have one clarifying question. You keep referring to the owner as Greg Siegel, and our record shows it's a trust. And the record, I believe, says that there is an older immobile woman who owns the property. Can you explain that discrepancy quickly?
I really can't. The only one that I've met and had to deal with and had to keep receiving, that I've had to keep fighting with and receiving messages being relayed to me from the previous manager, Linwood Porter, is Greg Siegel.
Thank you.
You're welcome.
That being all of our speakers, it is time for the tenant to have rebuttal. Or excuse me, not the tenant, I misspoke, the landlord for rebuttal.
In this case, I actually would rather use it as a public comment as a tenant myself, since I'm not in a position to rebut.
I'm going to have to defer to staff. I don't believe that's allowed, but.
As a public comment?
Yeah, he can make public comment. He has a right as you're a tenant?
Yes.
Yeah, but it would be under the public comment and not as the rebuttal.
So just 3 minutes, and I'm just concerned about giving one person 2 bites at the apple. Is no concerns with that?
No, because he's a landlord's representative for one and tenant and public comment.
And just reading the comment on the other. Okay, so for the record, you read the comments of somebody else previously, and you can proceed as public comment for 3 minutes. Just once again, for the record, state your name, and I'm sorry for all of that. I just want to make sure we're being fair to everybody.
Make sure I'm wearing the right hat. Again, my name is Damon Kirsch, and I reside at 917 Larrabee Street. I just want to speak on behalf of my experience with Rich Bonvino. I do also concur with what Sean was saying earlier, that he is a creative and hard worker for the building. I know the ways in which he goes out of his way to do what he can on the shoestring budget that he has. I have not met Greg Siegel. I know he is the representative of that trust that owns the building, who the family deals with the building. But just in terms of the responsibilities of the repairs and things that need to be done, I believe that Mr. Bonvino is doing everything in his power to keep the building safe, keep it clean, and do what needs to be done to keep it upkept.
Thank you. Generally, we would ask the commission if they had questions for the landlord's representative, but I don't believe we have a sufficient representative here to make those questions.
So the gentleman is not going to take the remaining water bottle and speak on behalf of the landlord?
I'm really not empowered to rebut or speak on their behalf.
Can I still ask a question?
I think you can ask it. Yeah, I think this is a weird situation.
I just want to ask a simple question because thank you, Chair. This is in regards to the statement that testimony that you made, your initial testimony. So you mentioned that there were photographs that you submitted. I think that's what you said.
I believe he has them in his possession. I don't know if they've been submitted to the commission or not.
Okay. I wanted to clarify, was anything submitted to the hearing or to the staff or commission or anything like that?
I don't know. Literally, this fell in my lap an hour ago, so.
No worries. Thank you. Thank you, Chair.
Thank you. Thank you very much. That would conclude our public comment at this time. I'm going to go out on a limb here, and anyone can voice an objection, but I think that we would all send our best wishes to the property manager as well. No, we're going to have a difficult conversation, I believe, but I think personalities are not involved, and we all wish him well in a speedy recovery. Any objections from the commission, or do I speak on behalf of us all? Thank you. Let's begin. So before we dive into this, there are 13 issues before us, and I think that if we just turn to each commissioner and debate the entire thing before us, we're going to be here all night long. So what I would like to do is go through, if there are objections, please state them. I would like to go through the order of the appeal, the way the landlord and their attorney outlines the issues. And I think that there are some of them we will probably have pretty close to consensus on, and we can just kind of skip past those. And then after we go through, I'll make a note here of those we want to discuss. So I'll ask, do you want to discuss this item? If you do, we will come back and discuss each of the items individually. I think that's going to move it along the fastest. Maybe it won't, but I'm going to try. I do want to also preface before we move forward with this and say, I'm going to encourage a period at the end to kind of summarize all of your thoughts so that everyone has the opportunity to say everything they want to. Any concerns with that approach? If it's not working, we'll change it. Commissioner Cafferty?
I just have one before we get into it. I just want to confirm, I'm pretty sure, but that the Airbnb example and the testimony is outside of this.
Correct.
Okay.
Yes.
Okay. But yeah, I'm down with your plan.
Okay. And if I'm, Commissioner Vice Chair.
Moving forward with your plan, I'll let you know, my tentative is to firm as to everything. So you wouldn't even have to check in with me. I don't know if anyone else is like.
Well, I'm just going to ask people if they
on an individual basis, but I'm a firm as to everything right now.
Okay, so I'm going to start with the continuation of the hearing. Is there anybody who wants to discuss that? Okay. The examiner impartiality. Washers and dryers. Commissioner Kirpies wants to talk about that. Okay, we'll come back to it. The structural cracks. Okay. Mold in common areas. The closed caption TV and ring camera. I want to talk about that.
I just want to make a quick comment about that.
Okay, I'm marking the ones we're going to come back to and talk about. The unclean common areas and walkways. Okay. The pool. Okay. The dead and decaying plants and bug infestations. The plumbing. I'm going to speak on that. The on-site manager. Okay, we're going to talk about that. Items being stored in public areas, yes, okay. And the keyless access, I want to talk about that. And the leaky roof. We crossed half of them off the list. It might actually work here. And I think in our closing comments, we probably will have comments on those things. We're not going to debate further, but let's start with the washers and dryers and see where people are on that conversation. That's the first one on my list. Commissioner Kirpies.
So there's no doubt in my mind the washers and dryers are a reduction in service, and there needs to be a reduction in rent. What I do think the hearing examiner erred and misunderstood maybe the direction, or at least how I would have interpreted the direction. It's almost as if the hearing examiner decided to place a value on each of the washers and dryers that were, and it doesn't seem like they did. That's what they explained it. But again, kind of similar to what I was mentioning in the last case, it's the service it's the reduction in services that I'm looking at. And so I just find the value of $492 for the lack of service of having a washer and dryer quite high compared to our other cases. And I'll leave that. So I think that, using the hearing examiners to resolve that, using the hearing examiners' same reasoning, I would narrow it down to whatever the value he or she gave to the washer and the value that he or she gave to the dryer, combine those two together to be one reduction in service. If that makes sense, what I just explained.
That was $82 each, so that's $164. That's what you're suggesting?
And I would be much more, I think that's much more fair and much more reasonable.
Okay. Commissioner Tops, do you have additional?
I don't know if the examiner if the examiner way of thinking was to apply per washer and per dryer. If that was the decision of the examiner, I fully support that, because it goes based on the actual appliances, the number of machines versus just the service. The service could be one washer and one dryer, could be 5 or 6. So more machines, more services, that would be a greater value to the service that is provided to the tenant, especially with multiple units. So I agree with the determination on the amount.
Anyone else on this one? I have something, if no one else. I tend to agree with Commissioner Kirpies that the value assigned to the washers and dryers is excessive compared to previous cases at $492. I think that there's two ways to approach it. One, the way Commissioner Kirpies does, where we do $82 for the washers and $82 for the dryers, meaning a reduction of $164. I think another way, piggybacking off of what Commissioner Topchin says, is that we do a value per machine. There are 6 machines, and the valuation guidelines give us a range of $45 to $127. So we could also reduce it to $45 per machine, meaning a reduction of $270 instead of $492, which gets us closer to the number Commissioner Kirpies is suggesting. Before we move on from washers and dryers, let's just kind of do a straw poll here and kind of see, do we want to keep the hearing examiner's evaluation? Their legal counsel wants me to stop talking for a moment.
I just want to clarify on the guidelines. I believe you're going of the in-unit range, and these are common area.
I could have made that mistake.
Yeah. So The common area washer is 30 to 84, common area dryer is 30 to 84, whereas in-unit is 45 to 127 for each of those.
Okay, so redo that math. 30 times 6 is 180. That's much closer. So if we do it per machine at the minimum amount, that's $180 per unit versus the 492. What is the appetite of the commission? To keep the hearing examiner's number, Commissioner Kirby's number, or my number? Or something else?
I'm curious, why is that number? Do we know how they came to that number and why it's so different from previous experience of my colleagues?
You're asking the commissioners or you're asking the staff?
Staff, yeah.
It's in the decision. That being said, I'd have to look for it.
Is it 492? Is
Yes.
that the reductions? And there's 6? So that's 82
I think
times
they
6.
kind of split the middle, went down the middle on the evaluation guidelines. That's just my memory. So the midpoint, I think, is 82, and they did it per machine. I'm suggesting we do the low end of that,
So,
but by machine.
Chair, sorry, real quick. So
Please.
I believe 82 was, it might have been the old guideline number. 82 was the max per machine. And so if it's 82 times 6, that's 492, which would get you to where they placed it.
Thank you. Commissioner McCafferty?
I agree with the 492 number. I think if you rented an apartment and you want there to be, I could see someone renting an apartment and being like, okay, I want access to multiple machines, as opposed to picking a different apartment with one machine. Like you entered in the lease with the services of multiple machines, and so I'm going to stick with the 492.
Affirm as to 492, that would be my inclination.
492, that's suggested guidelines, whatever the examiner was thinking. It seems it is within the guidelines, although these guidelines are suggested, they can go above and beyond the guidelines if the service, depending on the value of the service or the importance, the significant importance of the service, and the inconvenience and comfort when the service is removed, right? These are the factors that the examiner looks into. And I think the $82 is reasonable, not excessive, and I would definitely support that.
Commissioner Paris?
Chair, real quick, can I
Please.
add one more thing? So in the guidelines, I want to draw the commission's attention. Mr. Kessinger pointed this out. Each value listed is intended to apply to the loss of each distinct item lost. So you're correctly interpreting it. I just want to say there's support for that in the regulations. And their example is window means one window. So if there's a crack in it, it would be one. If they're all cracked, you multiply. So it's correctly done how you're thinking it.
Commissioner Paris, I'm trying to take a straw poll so we can move on from this. So
No, I'm inclined to agree with the examiner
great.
on this.
And Commissioner Goldman, I don't think I've asked.
I agree with the examiner as well.
And I want to be clear, I believe that the hearing examiner was correct in awarding a reduction for the washers and dryers. I just thought the amount was excessive. So I would affirm the hearing examiner there. So seeing that the majority is there, I think we can move on. The next one we had on here was the Ring camera and the closed circuit TV. I had to speak about that, but Commissioner Topchin, you too?
Yeah.
Please.
It's a quick comment. I think I read in the report that I think the landlord's argument that CCTV cannot be considered as a landlord-provided housing service, and that is incorrect. Anything that is available at the time of, anything that is available to the tenant for the tenant's use and the benefit of the tenancy, that is a landlord-provided housing service. And if it's removed or not available, that would constitute a reduction in housing services. So that was just the argument, and I would agree with the recommendation on the amount of the rent reduction, because clearly the purpose of this service was to provide safety and security, and you don't see that many buildings that would have this type of service available for the tenants. And especially these days, where things are happening, crazy things are happening everywhere. So I think this is a really important service if it was available to the tenants. Thank you.
Thank you. I want to suggest that in my own building, the city did a program a few years ago where they were helping residents buy Ring cameras, and I bought one, and I asked my landlord where I could install it, and they said I couldn't install it. My landlord did, because then that would be a housing service provided for in perpetuity after I moved out of there, so I was not able to install that. So I agree with what Commissioner Topton just said, is if you install something, even if it's after the lease commences, it is a service, and so the hearing examiner was correct on this. However, regardless of the conversation we just had about washers and dryers, and it's per item, here the hearing examiner made a determination that they should have a reduction per camera, but the evaluation guidelines actually call it a security system and cameras. It's one of the only ones that's plural, so I think it should actually only be a reduction for the entire system, not a reduction per camera. So currently the hearing examiner recommends a reduction of $240 per month. I'm suggesting the high end of the valuation guidelines of $159 instead of $240. Is there any appetite to reduce that reduction from $240 to $159?
Are we still straw polling?
Yes.
I'm good with that reduction.
You're good with that reduction. Are we the only two?
I would keep it where it's at. That's just me.
Commissioner Topton?
I would keep at 240.
Okay.
Keep it if you're expecting X amount of cameras.
Okay. We are at a majority, but I want to make sure everyone has a chance to speak. Commissioner Kerpes and Goldman?
I am undecided in terms of, I mean, I would still listen to more discussion if there was more discussion about it. But if I were to look at the two items, again, my issue is the overall dollar amount. So that's what I'm looking for at the end. I would prefer it to be more clear in the final outcome, but out of fairness, I would support that only because of the averages and the total dollar.
Commissioner Goldman?
I would keep it the way it is.
Thank you. I'm just trying to make sure we can get through all of these. Unclean common area and walkway. There was some appetite to discuss this, Commissioner Kerpes?
Yeah, and if I could combine, my issue with that one is actually combining the two that I mentioned, that one, and then, what was it, two down below that one? It was the storage issue.
Please.
So I see these, so oftentimes when we talk about storage, we talk about the loss of storage space. And in this case, I don't think that that's the issue. The issue is the people are using their areas for storage and causing clutter. And I find clutter, and I kind of find the two issues one and the same, whether it's dirty, cluttered, dusty, wet. The problem or the value is all, I'm saying this very well. I find these as the same issue. So I feel that they should be combined into one, those two that are currently separate in the hearing examiner's decision.
So just one reduction for both of those areas?
For both of those two items.
Two items, yeah. Areas of discussion, whatever. Is there any appetite to combine them and reduce that reduction?
I would keep it. I think the next step would be a compliance determination if the landlord wanted to pursue one, and I would want those issues separately analyzed, so I would keep them separate.
Thank you. Commissioner Pears and Topchin, either one of you?
I agree with the Vice Chair.
Thank you.
I just wanted to clarify, what were the two that...
The unclean common areas and walkway and the stored belongings.
Okay. No, I think separate.
But I think the point about the stored belongings, like we really shouldn't call it stored belongings. I mean, that's not the lack of service. If you look at the description, we should call it the description. So I'm just for that purpose.
I went off the landlord's appeal, and it's my own shorthand.
Okay.
So
I mean,
my language might be wrong.
That's what they say in there too. Yeah, that's what they listed as, but it's not.
Okay. Commissioner McCafferty and Commissioner Goldman.
What page does it analyze that $55 for the stored belongings? Like, are they doing that based off of a storage issue, or?
Yeah. Page Page 180 of our packet.
It's hard because I mean, me as a tenant, like I use my garage and my parking space as storage, and if my landlord put her stuff in my parking space, I would say you're taking away my storage. But this could be connected to like actual definitions and code. So skip me for a second while I mull over this.
Just to clarify, it's not that something was put in somebody else's storage. It's the photograph provided shows an accumulation of items such as a couch, a walker, crutches, shelves, and other randomly accumulated items. It's the problem here is the accumulation of items just out and about in the common area. That's, I believe, the complaint. It's not that somebody's storage was taken away.
I don't believe I would use the word hoarding, but that was used in the description, is that there's some complaints of hoarding-like behavior that needs to be cleaned up. That's how I understood it. So, Commissioner Goldman?
And so to clarify, you, Commissioner Kirby, you want to combine then you're saying dirty common areas and walkways and stored belongings because they're both in the common areas. You're saying that you want to combine that item.
Yeah, the overall complaint or the problem is the dirtiness, the uncleanliness, the scattered items, whether it be a rocker or a mattress or whatever else was there. But it's that's the problem. It's not that they're two separate issues. They're all part of a big problem.
Yeah, I mean,
This is all part of a big problem. I mean, and that's why we're taking this piecemeal approach tonight, which is good. So we can, but part of what's happening here is most appeals don't have this many issues. So clearly the examiner looked at this and was like, there's a lot of stuff going on here. I'm going to try to break it out as best I can. It sounds like you're making an amendment of form more for, because are you going to combine the two amounts and we're just going to group it as one category? In that case, that's just a formatting thing. I mean, the amounts are still going to be the same. Is that what you're suggesting?
I'm suggesting that they be combined, that the problem be combined, and if you look at the evaluations are based upon two different things in the recommendations for evaluations. I think he is erring by treating these two things as separate things. One he treats as the, I'm going to find the page again. They're two, they're treating them as two separate items in the recommendations and the recommendations. One is now just says this in reference to the scattered items underneath the garage and common area is the most analogous item as it relates to this one. Application is the issue of storage, which ranges from, so he's talking about storage. And that's, again, storage is not
What about
being
the
taken.
amounts? Are you suggesting the amounts stay the same and this just be lumped in one
I
category?
think that we should figure out what should it be evaluated upon. And I think that probably the other one is better, the evaluation that he used for the common area and walkways, which is...
Well, he's gardening landscaping for that one, which would not make sense to me for the furniture and stuff. I would not put that under gardening and landscaping.
So I guess that's another, I mean, that's another reason why I believe the hearing examiner erred is like...
Please use your microphone.
Oh, sorry. That's another reason why I'm saying the hearing examiner erred on these two, separating these two items. These are, in my view, the same problem at the site. And there will be if you look at the regulations and the evaluations, I believe that we could find one of those on the evaluation chart that would describe this sort of problem. The other problems are
general cleanliness issue.
very separate. I mean, you would not combine a garage door with this. You would not combine a broken window with a laundry room issue. This, to me, just seems like a mess.
While we wait for Commissioner McCafferty and Commissioner Goldman, I will say that I found the stored belongings to be the least persuasive and the only area that I would even entertain reversing, not to show my hand too early, but that I would consider reversing the hearing examiner. So I would be inclined to combine them because I think it's a general cleanliness issue. So that's where I'm at. I would support Commissioner Kirby's on that.
And if I could just reference the, in terms of the number of issues, so hearing examiners deal with a number of issues in multiple cases. It's just that we often on the appeal only see the items that are appealed. But if you look back at our cases into the original decision, you might see 20, 30 items that have been determined by the hearing examiner, and only 10 of them make it to us. So this just happens to be all of them because they've appealed on every single one.
So I have right now 3 people opposed to combining these, and the number and the 2 of us in favor to straw poll. Are either one of you prepared to weigh in?
Are these kind of categories that they've assigned, are these categories connected to code, or this is just how the examiner has used his or her best judgment to do it?
There's nothing in the code that speaks to this, so how he's written it is perfectly fine. There's just guidelines. Each department might have something that we can't all think about, so in that sense, there's not an error there.
My understanding in reading this was that it originated with the actual application and how they laid out issues, and it might have then changed when the hearing examiner wrote it, and they might have combined or looked at things differently. And then obviously where I pulled my list was from the actual appeal, and so that might even be different from.
In that case, if there's no defined categories, then I'll keep them as is. There's no reason to reorganize them that I see.
We have a majority, but Commissioner Goldman, do you want to weigh in on this?
Yeah, so I'm inclined to think it does make sense to combine them because it's all common area and walkway issues, and if there wasn't a reason to separate them in terms of codes and what you're looking at, I think it makes sense to combine them, so I would agree.
Great. Well, there's still not majority not to, but I appreciate not being in such a small minority. Let's move on to plumbing. I want to talk about this. Is there anyone else? To plumbing? I simply want to say that the testimony showed that oftentimes there's brown water running out, and the landlord describes that as good working order, and I'm just going to be really frank tonight that only a slumlord would suggest brown water running from the tap in West Hollywood is good working order. I needed to say that. An on-site manager. Did you have something on plumbing? I'm sorry, Mr. Commissioner.
No, I had for on-site manager.
On-site manager, take the lead. There's no public comment until the end of the meeting. Please, Commissioner Thompson.
Thank you, Chair. It's just more of like a comment, maybe. Well, I would say that I agree with the amount of the reduction for the on-site manager. I believe that was last year. I think the city council would have passed something. I believe the ordinance. I don't want to be misspoken about it, but I think there was an ordinance or something regarding the resident managers and how city council looks very strongly into this type of cases when the landlord's representatives, the on-site manager, doesn't perform the duties as to the standards that is expected of by the code. So just wanted to make it clear that the resident manager represents the property owner, represents the landlord, and has the responsibilities of the landlord. So the landlord may be somewhere in the Cayman Islands, right? So property owner, but that's why the property owner, the landlord, appoints a representative, and that person will be a resident manager. and that resident manager has all the authority and the duties and the responsibility to act on behalf of the landlord, and in a sense is responsible for what's going on the property. So I understand that there are some health issues, and I definitely wish him well. And I heard some positive comments about the resident manager, but the law is that the law requires in West Hollywood to have that resident manager's hours and contact information, everything available. And plus, there are certain expectation of the resident manager to perform the duties to the point that there would be no code violation. And here I'm going through this case, and all I see is like notice of violation, notice of violation, notice of violation issued by the city. So that shows the lack of responsibility of the resident manager doing what he has to do. So therefore, in a sense, I would say, I don't know if I didn't check the amount of the reduction for the resident manager, if this is the high end. So I would actually, well, although I said that I agree with it, so I definitely don't want to go lower than that, but I want to see if we can entertain something that we can actually increase the amount for the reduction, considering how important this service is in West Hollywood, and how important the legislator took this type of cases when they heard the resident manager item last year. So that's basically my comment. Thank you. And yeah, if Chair, if you have a list of those suggested guidelines, suggested violations, what is the
manager
range?
in the current evaluations is 14 to 116. So my understanding is that at the time of the hearing, we had not yet raised the number. Okay. So 113 was the max at that time.
Okay, so I'm fine with it. Thank you.
I also want to speak on the on-site manager, and I was somewhat offended by the appeal suggesting that our only option here as a commission was to suggest that the landlord had to fire the building manager or just accept how it is. And I just don't think those are our two options here. People often go for medical reasons and unable to perform their job, and it is the responsibility of the business owner to find somebody to do that work while this building manager takes care of his health. And that is the building manager's priority right now, and we wish him well, but it is not the landlord's place to tell us that the options are simply to fire him or just accept how things are. There is a third option here, and that is what the hearing examiner has determined. So I believe that number is correct, and I agreed with Commissioner Topchin. Because of the nature of all of these complaints, it needs to be the maximum number on that particular one. The next item is keyless access. Unless there was somebody else on bill. Okay. Keyless access, I wanted to say here that again, I just, maybe it is inappropriate, but I'm going to say it again, that the landlords, actually, I put it in quotes in my own notes here. On page 162 of our packets, it reads in part, quote, "The tenant should not complain to the landlord when the foreseeable consequence of their demand comes to fruition." And again, the landlord's responsibility is to take care of this property, and if they provided keyless access at any point during the tenancy, they are required to replace that or accept a rent reduction. And if the tenants have concerns about people misusing that, it is still the landlord's responsibility here, and to dictate in their letter that essentially what I read as similar to a threat just feels, it smells a lot like tenant harassment to me. Anyone else have something on the keyless access? That was less about keyless access, but more about the appeal speaking to keyless access. We had no one address issues of leaky roof, so I think we've gone through the list, and from my vote count, we are prepared to affirm, but I want to give everybody the opportunity to speak overall comments at this point in time. If anyone would like to begin. Commissioner McCafferty.
I'll start. This was a heavy case. It was pretty devastating. I think like the Blackwater picture will haunt me for a while. I really encourage the landlord and his team to, turn it around. There's no time like the present. But yeah, I firmly stand behind the rent reduction that's in the case.
Commissioner Kerpes.
Yeah, so I want to make very clear that I am absolutely appalled by the situation that the tenants have had to go through in this situation or the circumstances as well. I still have a very, very, I will probably approve, or I will probably vote in support of the decision or the motion that's going to be made tonight. But I do want to state very much for the record that I think that $492 for lack of laundry service is way too high. There's only so many clothes you can wash, and the examples that were given earlier about, I wanted extra so I would never have to worry about when I went down to the laundry room. That's still, again, you're only washing so many clothes. Sure, put another $10 on value on it so you don't have to wait. But $492 is the highest I've ever seen. It's ridiculous in my mind. And I think that one of the things we didn't talk about tonight, and I don't want to open up a can of worms about this, but the hearing examiner also, and this is something that Commissioner Topchian worked hard to get included in the evaluation guidelines, is that the hearing examiner should also take into consideration the dollar amount of the rent. I haven't asked the question. I found the answer in here, but I'm very concerned about how close we are to wiping out at least one individual's rent 100%. I mean, as much as I personally think that person might deserve it, I don't know how we stand legally, counsel, if that were to stand up in court in the future. I've never seen a case like this where we've come so close to almost zeroing out the rent. So that I have concern with overall, but my real issue is I'm 100% with the overall decision. I think there were some mistakes made by the hearing examiner on those two issues I think should be combined, but I'm much more worried about the $492 for the loss of laundry services. But I will probably support you.
Okay.
I would also like to state that this was pretty appalling to see all of these things that the tenants had to go through. And I would affirm the decisions, these reductions here. And if the landlord disagrees with something, I would encourage them to fix the things and then request compliance determination from the city.
Thank you. This side, Commissioner Paris?
I'm also inclined to affirm the examiner's decision. The state of this property is quite disturbing in many ways, and the tone which the landlord has taken in their responses is dismissive, to say the least, to my colleagues' concerns about wiping out a particular tenant's rent. The cure is to repair the damages, and I would support the resolution to affirm.
Thank you, Commissioner Topchin.
Thank you, Chair. What can I say? It's just the totality of these issues and the violations that affected the tenants in this building is just beyond belief to me. I haven't seen any case like this for so many years. And if we say that the pictures speak louder than words, obviously this photographic images, they're horrific. And I kept going through them when the landlord's representative or the manager's representative was saying that this was fixed, this was fixed, this was fixed. If things were fixed, file for compliance determination. That's all I can say. But based on the photographic images, the conditions are horrific. And I feel really bad. This is a time when I would just say, I don't believe the examiner was excessive by applying probably the higher end of the guidelines. These are suggested guidelines. They provide ranges, lower amount and a higher amount. So the examiner could go actually above what is given at the higher end of the guidelines. So the examiner probably look into the rents, because I'm pretty sure the examiners look into the factors to determine the amount per case. And again, whatever the examiner was thinking at the time of making the decision on the $80 rent decrease for the laundry services for the washer and dryers, and the legal counsel explained that it goes based on the appliance, based on the machine, basically. So I don't think that was excessive. So there are 6 machines, and if there are 6, all of them are damaged or not working, then there would be 6 times 82. I don't disagree with that. I just wanted to, kind of make my comment in that regard. But the condition of this building is really bad, and the landlord needs to do something, because this rent reduction will remain in place until all these things are done, corrected. And probably will be some other inspections and notices of code violations issued, and I don't know what is the other avenue that the city may consider in the future if these violations continue, because we're not saying that, you know what, things may be, you may have this black water running in your sink, all the landlord has to do is give you a rent reduction and do nothing. I don't believe so. I do believe there could be some other consequences to that. So, because we live in West Hollywood and we have high standards for rental units, the expectation is really high. If you are in the business of renting an apartment building, you, landlord, have a responsibility. And this is a heavily regulated industry. So you like it, you don't like it, this is West Hollywood, there is a rent stabilization ordinance, there are requirements under the code, you must comply. If you don't comply, there would be severe consequences. So that's basically my message, and I agree with the staff's recommendation in its entirety. I'm going to support it. Thank you.
Our Vice Chair.
I just want to say thank you very much for all the tenants coming out tonight, everyone coming out to speak on this issue. I think I don't have anything to add that hasn't already been said by my fellow commissioners. I will support a motion to affirm the resolution. And I'll just add that it's sad that you had to make these complaints. It's sad that you're having to live this moment, but I'm kind of proud of the process that the city has and the ordinance and the ability for people to seek relief in this setting, and the future relief is the compliance determination. So the process is working and doing the right things, so I would support a motion to affirm.
Thank you very much. I want to echo what my colleagues have said. I am in the same position as Commissioner Kirby's. We generally vote against each other on a lot of things, so tonight's an abnormality, but I believe the washer and dryer amount was excessive. And so I believe we should do, leaning on the last case, I mean, the washers and dryers work a little bit once in a while. And so I just think it should be the lower amount. And that still would come out to $180 a month reduction per apartment that has not opted out, rather than $492. It would be instead of the $1,551.25, it would be $312 less per month. That's where I'm at on that. But I believe the hearing examiner was correct in finding that there should be a reduction for those 6 machines. So that's where I'm at. I don't believe that there is more than Commissioner Kirby's and I at that place, but I do want to state that that's where I stand, and I will trust the wisdom of this commission on the dollar amount and the hearing examiner. But I want to speak about one thing we have not discussed so far, and that is if you turn to page 182 of our packet, which is page 16 of the hearing examiner's decision. There is a section in the middle of the page that says tenant intimidation and harassment issue not listed. I have read about 100 hearing examiner decisions between three of my own, 18 months on this commission, and just being a concerned citizen who occasionally is the nerd who reads hearing examiner decisions about things because I care. I have not seen, and it might have happened, but I have not seen a hearing examiner insert something like that before. And I just want to echo that I also affirm, and I don't believe this needs to be part of our motion, but personally, I affirm the hearing examiner's suggestion that there could very well be tenant intimidation and harassment. And I, for one, would like to encourage the city attorney's office to investigate this landlord and this property. And all I can do is, as a commissioner, suggest that that is something staff should look into. That is a city council decision and not ours, so I'm not suggesting any sort of change here, except to be heard on that position. Because I think Commissioner Kirby's and I are in the minority on that, but I support the overall position, I would turn to somebody else to make a motion.
I would like to, hang on one second. I'd like to make a motion to adopt resolution RSC number 24660, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D4877.
Second.
We have a motion and a second. May we have a roll call?
Commissioner Goldman,
Aye.
Commissioner Kirpies,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topson,
Aye.
Vice Chair Rory,
Aye.
Chair Bass.
Aye. This motion passes. So if the parties have any further questions, you may reach out to the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. That is the end of this appeal, and so we will move on to the next item of business, which is items from staff. Do we have anything at this time?
No items from staff at this time, thank you.
Thank you. I know that there was somebody who desired to speak a short time ago. This would be the opportunity for that, if anyone has comments that they would like the commission to hear at this time. Is there anything, Mr. Secretary?
No further public comments.
I'm looking at the audience. No one's raising their hands, so we will move on. Now we turn to items from commissioners. No comments on my left. Any comments, Commissioner Kirpies?
I just want to wish everyone happy holidays, and also I agree with your comments earlier. I would actually go a step further. I'm not demanding or calling, but I would be very disappointed as a resident of the city if code enforcement and or the city attorney's office wasn't already involved in this case, because it is, or in the previous case, because it's really bad.
Thank you. Any other comments to my right? I just want to say that I appreciate the work of this commission. I know that particularly our first hearing, there was a lot of contention on that. But what I do appreciate about the six of you is that you come to this meeting prepared and looking after, I believe all seven of us look after the best interest of our community. And I hate it when we have contention up here, but we have contentious issues. And so I just wanted to voice my appreciation for you and for staff for helping us get through that. So that is it. So we will adjourn. I'm going to have to look up a date because we're January 9th, okay. So this meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on January 9th, 2025 in West Hollywood Park Public Meeting Room, Council Chambers. That's this room. Happy holidays. Good night.